He asked Patricia whether she or her son should die first. And they talk about the stab wound, how it went through his arm and into his abdomen. Djerf tapes the wire end to the boy and tries to electrocute him to death at this home where the Luna family had been murdered.
The police did nothing.
You know, last week we did the Tyson murders. Interesting discussion. Today we're going to shift gears just a little bit. Also another homicide case. We typically do these homicide cases more often than not because they involve interesting issues. And each one it's like peeling an onion, right? It gives you another layer into how the courts operate. And so today we're going to talk about State versus Richard Kenneth Djerf.
Yeah, and this one is different than what we've done before, right?
Very different.
It's a plea agreement, whereas a lot of times we've looked at, and last week we didn't really look at the trial part of it because there wasn't a lot of information available, but usually that's kind of our focus. But this one has some interesting issues with the plea.
Yeah, and so Richard Djerf, his last name is spelled D-J-E-R-F, but in doing the research for this case, I learned that D is silent. It's Djerf.
Not a lot of vowels.
No.
Just got the one.
Djerf, Richard Djerf. So this one is interesting, and it caught my attention mostly because Mr. Djerf was executed about 2 weeks ago. This was a man who was on death row for a long time. Nearly 30 years he was on death row and was ultimately put to death on October 17th of this year, just a couple of weeks ago. And what's most interesting, I suppose, today is November 6th, 2025. Mr. Djerf was born in Phoenix on November 6th, 1969. So today would have been his birthday. But due to his actions of his own, he was executed. But how did we get there? That's what we're going to talk about. So this case actually occurred more than 30 years ago, 32 years ago, September 14th, 1993. Let me set the stage for you. So
Ugly murder.
Really?
Guys,
right,
just a little prep for you if you're not able to handle kind of pretty ugly facts. This might not be the episode.
This one's awful. And in fact, I watched an interview, the first police officer, to show up on the scene at this home where the Luna family had been murdered. And this officer, I think, has been forever scarred from what he saw inside that household. And so these are grisly facts. They're ugly facts. You'll understand, hopefully better after our discussion, why the death penalty was imposed on this case. Now, we talked last time. You may disagree with the death penalty, and that's totally fine. I'm not here to advocate for the death penalty, but certainly a case like this helps one to understand why it might be imposed.
Right, and that's really what it is, right, is to talk through what are the legal standards, why might it be imposed, why might it be sought by the prosecution, what do they have to prove, and kind of that process without really making value judgments about it.
Sure, and again, we told you last time, or we suggested last time, that you search your soul and you decide, is the death penalty something that you support or is it not? And we'll give you some sort of insight into this case and why it was. So this case, again, it's in 1993. At that time, Djerf was 23 years old, okay? He had met a guy, his name was Albert Luna Jr., okay? So he is the son, and he's a similar age fellow as Djerf was back in 1993. These two worked at a grocery store late at night. They were, kind of restocking the place.
A Safeway.
A Safeway. What happened was that Albert Luna Jr. Supposedly burglarized Djerf's home, took some stuff, a gun, stereo equipment, VCR. I don't think we don't own a VCR at all. Do you still own a VCR?
No,
I can't imagine.
No, at one point I went out and got one.
Bought one?
Because when I was at the county attorney's office, 2012, the DPS, their dash camera, they would provide it to us on VHS, and you couldn't watch it anywhere. And I'm like, guys,
so you go out and buy.
So I had to go buy one. Yeah, when I'm making like $50 a day at the county attorney's office.
But in 1993, a VCR is a hot commodity.
It was. They were expensive.
They also it's one of the items that Djerf stole from the Luna family was a caller ID module. Do you remember those?
No, I don't remember.
This was something. This was something that you had your landline. You plug the landline into the wall. The line from the wall goes through the caller ID, and then from the caller ID into the phone. So it sort of intercepts the line, and then it pops up with who's calling. Yeah, that's right.
Yeah.
Groundbreaking.
Yeah.
In 1993.
Yeah.
Okay. In any event, Luna Jr. steals some things from Djerf. Djerf is upset about that. He calls the police. He says, this guy, Luna, robbed or burglarized my home.
An AK-47.
An AK-47 was stolen, too.
Yeah.
Djerf is upset because although he had pointed to Luna as the suspect, Phoenix police didn't do a whole lot to investigate or, solve this burglary.
I thought it was interesting in the facts. I don't know if they're trying to just talk from Djerf's perspective and they're just adopting his perspective. Mm-hmm. They said the police did nothing. That's what they said.
Yeah.
in the facts.
Right. And I think that is... Nobody's disputing that.
Yeah.
Maybe the officers at the time would have said,
hey, wait a minute.
Hold the phone. Anyway, Djerf is upset about that. And so what he does is on this day, September 14th, 1993, he goes to the Luna's home in Phoenix. He's got a pistol. He's got some fake flowers. He knocks on the door. A knife. Gloves, he has some other implements with
a red fuse cord.
Right.
Yeah.
In any event, he knocks on the door. The mom answered. So Luna Jr.'s mom answers the door. She's in her early 40s. He forces his way in. Inside is her 5-year-old son. I think his name is Damien. Mom and Damien are in the house. Richard then begins his crime spree. I'm just going to read some of it.
Yeah, we always struggle with how much to
I'll read
to put
some
into
of it.
the...
Patricia answered the door to receive the flowers. Defendant pushed his way into the house, showing her his gun, took Patricia into the master bedroom, bound her, letting her 5-year-old son Damien run free. Later, while holding Damien hostage, defendant freed Patricia, forced her to place items of property into the Luna family car, including 2 VCR units, a telephone, a caller ID box, a stereo CD player, 4 watches, change, money clip with food stamps. He then took Patricia and Damien into the kitchen, bound them to the chairs with rope and black electrical tape. More than once, he asked Patricia whether she or her son should die first. He also asked her if she knew the whereabouts of their son, Albert Jr. So his beef was with Albert Jr. So he goes in, he bounds her, he burglarizes the home, takes property, has her, and puts it into the car. That afternoon, while he's still in the home, their oldest daughter, Rochelle, comes to the door. She goes inside. Go ahead.
And the mom and the son are strapped and tied to a chair already.
They're bound.
So they've been there for a while. When Rochelle, the 18-year-old daughter, comes home.
So he then takes her into a bedroom where he gags her, ties her, sexually assaults her.
Cuts her clothes off with a knife.
Brutalizes her, essentially stabs her multiple times, slits her throat, murders her. He then comes out, and that's horrific enough in and of itself. By itself, that's horrific. He then comes out, tells the mom and the young boy, I just murdered your daughter, your sister.
And what he just did.
Right. And then so they're having to live with this. They're still alive. He hasn't hurt them yet. Around 4 p.m., Albert Luna Sr. comes home. So this is the father. He's in his later 40s. Arrives home from work. Defendant handcuffed him, forced him to crawl to the master bedroom, placed him face down on the bed. He struck Albert in the back of the head multiple times with an aluminum baseball bat, inflicting 3 large lacerations, spattering blood throughout the room. The medical examiner testified that hemorrhaging from these wounds was potentially fatal. Defendant removed the handcuffs from Albert, taped his hands together, left him for dead. He then walked into the kitchen and told Patricia that he had killed her husband. So this poor mom and child are having to be in this home while the daughter is killed, while the husband is killed. Then, it's awful. Djerf then tries to take the little boy and snap his neck like what you see in the movies, this sort of action.
And
with
apparently
the form.
that was from his statement to say that it was like he'd seen in the movies.
Right, and it didn't work. I don't know how, what damage or what pain that inflicted onto the young boy, but what an awful scene for that mom to witness and for that boy to be in.
Well, and what is
Additionally,
that piece that says that he actually turned his head all the way around?
Yeah, he kind of, I don't know, awful. The boy survived that. Djerf then cuts a cord off of a lamp and tapes the wire end to the boy and tries to electrocute him to death. That doesn't work. But what torture, okay? Meanwhile, Albert, the husband, is able to free himself and then comes at Djerf with a knife. He's actually able to stab Djerf with a knife. Djerf then takes this Beretta pistol that he had and shot Albert 6 times, killing him.
I think he stabbed him
He
a
also
bunch of times
stabbed him.
first.
And they talk about the stab wound, how it went through his arm and into his abdomen. A very deep stab wound, of course, and then Albert, is finished by through the shooting.
Falls at his wife and son's feet.
Just awful, awful. And then as sort of this end point, he again asks Patricia. Now the daughter is dead, the husband is dead. Tells Patricia, do you want to go first or do you want your son? He ends up shooting both of them at close range. He then tries to dispose of the scene by spreading gasoline around. He originally was going to light that fuse, but later changed his mind, I think. Ends up putting a pizza box on a stove with a rag, turns the stove on with the idea that it would ignite, hit the gasoline, light the place on fire as sort of a timed arson where he would have time to escape and then leave. It didn't happen. It turns out that smoldered or whatever. It did not catch fire. It did not burn the scene. A day goes by, okay? Then Albert Jr. He comes to the house, discovers the scene, calls the police. In the meantime, Djerf had initially said that somebody had stabbed him. He had gone to the hospital. Ultimately, he tells his girlfriend and others about all of the things that he did, almost glorifying it, reveling in his own acts, talking about how cool it was or
awesome.
whatever. Yeah. Crazy, right?
Yeah.
Horrible scene. I mean, you can only imagine what the junior experienced when he walked in to find his family just slaughtered like that. Police, again, this officer whose interview I watched said that it was the most horrific thing that he'd ever seen, and you can see why. I mean, what an amount of suffering, what an amount of carnage that was going on. Awful, awful situation.
Pretty bad. I mean, we've talked about some really bad cases and some bad facts. This is one of the worst. I mean,
one of the worst.
Just the amount of time as well. It was
all day long.
All day.
All day long.
Just torturing and murdering this family.
So he was charged with, I think, 18 different counts. 4 of those were, of course, the first-degree murders. And again, like we did with the Tysons, we're going to focus on those because that becomes the centerpiece for the legal actions that take place. So those are the facts, okay?
Yeah, so, and just jumping in, if let me know if I'm going ahead too far, but one of the interesting things then is, when you're charged with a crime and you have counsel, you have an attorney, sometimes people will say, hey, I want to represent myself. He was assigned very experienced, very good counsel. I don't know if you know Alan.
Alan Simpson. Mm-hmm.
Yeah, very, very good attorney. And he said, I want to represent myself, right?
And that's that is really the lead issue that we're going to start with. And so he says, I want to represent myself. Now, we all know that under the Sixth Amendment, anybody who's charged with a serious offense, meaning where jail is a possibility, you have the right to have counsel appointed for you if you cannot afford counsel. But it's interesting because the inverse is true. Okay, you also have what the Supreme Court calls a fundamental right to represent yourself. If you do not want counsel, you do not have to have counsel. And I'll just read this from the opinion. The federal and state constitutions guarantee the right to waive counsel and represent oneself. Self-representation is, quote, a fundamental constitutional right.
Yeah, you don't think about that a
lot.
lot.
No, you don't about that. You think, I've got a right to a lawyer.
Right.
You also have a right not to have a lawyer.
Right, yeah, really, really interesting. And we're going to talk about it through as well about when that happens, the court's got to be careful, right?
Very
about
careful.
How they do that. And this case is just such a good example of that because We experience it every day.
Sure.
Right? We're in court, and there's a very specific set of things that get said to every person who's entering a plea agreement, any person who we might suspect has mental health issues, we might, or who says they want to represent themselves. There's a very specific set of things that have to be done, and this case is a good example of why that's so important.
Yeah, and the court starts really any case with the presumption that counsel will be appointed, right?
Especially murder serious cases.
Of course.
Yeah. And almost nobody can afford this type of counsel.
Capital
for a
counsel.
capital case.
For sure. Yeah. And so the court, though, says, and this is important, again, our listeners need to understand this, one important restriction on the right is the waiver of counsel must be made knowingly, intelligently, and voluntarily. Meaning, if you're charged with an offense and you say, Judge, I do not want a lawyer representing me, I want to represent myself, your waiver of your right to counsel has to be a knowing waiver, it has to be an intelligent waiver, it has to be voluntary, meaning it can't be the product of threats. You can't suffer from some mental disease or defect, and you have to do it of your own free will, meaning you've got to smartly make this decision, and the judge needs to do that. And so what does the court do as a practical matter? It goes through what we call a colloquy, where the judge asks you questions to verify, are you doing this voluntarily, knowingly, and all of that.
And it also creates a record.
And it creates a record.
When the appeal happens,
That's right.
They can say, look, we did all this stuff.
And so what happened in this case is the trial judge says, okay, I find that Mr. Djerf's waiver of counsel is knowing, intelligent, and voluntary, and he had done the things on the record to allow him to be able to make that decision.
It's an important,
those two lawyers that were appointed to represent him then take sort of a back seat. They're still on the case. As a matter of caution, the court appoints what they call advisory counsel in case you've got questions while you're representing yourself or you need research done or other things. That advisory counsel stands as backup, but you're the attorney.
Yeah, and it's interesting too that they take it very seriously. The judge doesn't just say one day in a pretrial conference, which is kind of just a pretty common conference that you have where you all just kind of report to the judge how you're doing in the negotiation process and the trial preparation process, right? And you don't just have a guy who just one time says, I want to represent myself. Judge says, okay, cool, right? This judge set a separate date for a hearing to talk about it.
That's right.
And so they went through it really carefully.
And of course, like you said earlier, it's all done on the record. There's a court reporter. There's a record that is made so that if there's any question later on, we can refer to the record and say, nope, that's what was said. This is what was done. Now, what's interesting is after the court says, yes, you can represent yourself, about 3 weeks later, I think the prosecutor's office smartly says, well, Judge, we want a Rule 11 evaluation, at the very least a pre-screen. Okay,
have we talked about Rule 11
We have not.
Yet?
And so this opens an interesting door. Rule 11 in Arizona refers to competency, specifically the defendant's competency to participate in criminal proceedings. They have to understand the nature of the charges that they face, and they have to be able to participate and help defend against those allegations. Rule 11 is that examination of competency. Can they meet that hurdle? Now, arguably, that Rule 11 competency line is fairly low. You don't have to be brilliant. You don't have to be able to do it all. You have to understand and participate.
You don't even have to be free of mental health issues.
No.
There's many people that have pretty serious mental health issues, but they are found competent. Yeah.
So how does this work? Well, the rules say anybody at any time can ask for a Rule 11 evaluation. Most commonly, we do it on the defense side. If I recognize that my client isn't understanding the things that I'm saying, or maybe they're sort of their wheels are spinning and it's like I have to repeat myself over and over.
Asking the same question.
Right.
Yeah.
Or if I know that they have a previous or underlying mental health condition or anything in their behavior strikes me as, hey, maybe they're not getting it, I want a mental health evaluation.
As soon as you suspect it, right? Because it's just, you don't want to create a record too either where you're having somebody plead to something or make a decision that they weren't mentally able to do correctly, but also in a self-preserving situation where you want to make sure that you did your part to alert the court and make sure your client's rights were protected so it doesn't come back and say, wow, you just, kind of screw over this client.
Right. And so what's the procedure? So I file a motion saying, Judge, I'd like a Rule 11 evaluation. Usually, 2 doctors are appointed. They evaluate the defendant, the client. they determine whether the client is competent, whether they meet that hurdle. Mm-hmm. If those two doctors agree that the person is competent, then Rule 11 proceedings end and the case continues on. If the doctors disagree with each other, one says competent, one says not, then a third is appointed as a tiebreaker. If both say, or 2 out of the 3 say he's not competent, that's not the end of the inquiry. What happens then is typically he'll be put in what we call restoration. That's education. So they're taught, sometimes they're medicated, but they go through a proceeding where they become competent. Now, you can say, well, what happens if they don't become competent? Well, if a person is not restorable and can never come to competency, well, then the case has to be dismissed. That's what the law says, is you can't hold someone accountable who's not competent. So Rule 11 may lead down a road where ultimately the charges are dismissed, okay? And that's rare. Yeah. But it happens.
It certainly happens. And, and I think that it's probably good to discuss kind of from a criminal defense perspective where the value is in the Rule 11 process. First of all, it can be really challenging to explain to your client what you're doing, right? Is to say, hey, look, I think you might have mental health issues that are so severe that you don't understand what's happening in the case. You got to be very tactful in how you present that. But also, I think there's value in it, even though the vast majority of the time they are found competent. And, what I see is I'm only going to ask for it if I legitimately believe there's an issue there or suspect it, even if you just suspect it because you just don't want to be wrong on that, is that they go through that process, and during that process, they do receive kind of an education on the the system a little bit. Maybe it helps them get to what I've been trying to teach them a little bit. But also, let's say you get through that system and they say, yes, they are competent. Okay. At that point, now we have 2 doctors, maybe 3, who have evaluated your client and talked about what are some of their mental health challenges that I can now present to the prosecutor to say, I'm not just making stuff. This isn't coming from me that this guy is, sometimes when we're making all these arguments for our client on why we should get a reduced outcome, it can seem like we're just making stuff up, right? I mean, obviously we do it in a way that is supported so that it doesn't happen. But I think that's a powerful thing for the prosecution to see a independent third party who has professional who's evaluated this person and can speak to the challenges they have, and it's at least mitigating.
Yeah, and it uncovers, as you said, perhaps other underlying mental health situations that we otherwise weren't aware of.
And we should know. Yeah.
So the prosecutor in this case, I want a Rule 11 evaluation. They do what's called a pre-screen, which is just having one doctor do the evaluation. And in many cases, that can be sufficient. And what this doctor, Dr. Potts, he actually, he's been around for a long time, did that evaluation. He says he's competent. The court creates a record of that competency. And then what's interesting about this case, as we touched on earlier, after he waives counsel, after he is found to be competent through Rule 11, he then enters a plea. Djerf does not go to trial. He pleads to 4 counts of first-degree murder, and the stipulations in the plea agreement are that the court can either impose life in prison or death.
Is that as unusual as it seems to me?
Of course.
Right, so
you rarely get somebody who enters a plea where death is still on the table.
Why? Why would you take the plea agreement that says, I admit to you that I committed these first-degree murders. It's up to you, judge, on whether to give me death or life. Now, it's pretty common in other type of cases where there's some discretion to the court on stuff like that, and there still would have been discretion to the court. But generally, you just don't see, at least in my experience, a first-degree murder case that is capital where they take the plea that allows them to be, because why wouldn't you just go to trial?
Sure. And that's why most capital cases go to trial. Now, the way you phrase that I think is really interesting because the court later on in some analysis of his situation of actually whether the death penalty was appropriate analyzes whether he had sufficient remorse to qualify as an aggravating factor. And what they find is, because Djerf says, oh, I'm so sorry, this is awful, I feel so badly, I'm remorseful. And the court says, I don't find that to be mitigating. Rather, I find that you entered a plea because of the overwhelming evidence that was against you.
Right.
And
he tried to say, I took it because I felt so bad. And he said, no, I think you took it because you knew you were going to be found guilty.
Right. Yeah. And so I still appreciate your point, and I think it's a valid one about going to trial in a capital case, because what have you got to lose?
If they're going to give you death anyway.
Except that perhaps in consultation with his lawyer, they thought, well, we can get the remorse as a mitigator that may cut away from the idea that the death will be imposed. Now, I don't disagree with that strategy, or at least the thinking behind that strategy, but it is something that I think has to be evaluated. So Djerf enters a plea agreement. What's really interesting about his plea agreement, and it's also something that he complains about later on, is how do you get from plea agreement to the sentencing where death or life in prison is imposed? Well, you have to do a hearing. And in this case, it's an evidentiary hearing where the state has to put on witnesses to prove, and we've talked about this, aggravating factors and mitigating factors.
And it's required, and it's really lengthy, and it's really thorough in a capital case.
That's right.
It's a huge part of a capital case.
One of the things that has changed since the 90s when this was happening to today is that judges no longer impose the death sentence. It's juries. I'll give you a quick history. Okay, Ring versus Arizona was a case that came out of Arizona that says if you're going to use aggravating factors to impose a death sentence, those aggravating factors have to be found by a jury, not a judge. Mm-hmm. Okay, so now death sentencing is done by a jury. Back then it was not. Now, a number of cases after Ring, capital cases, had to be resentenced and have a jury, even though they'd been decided before, they had to be resentenced and have a jury find the death sentence.
I wonder how much time and
effort
effort
that There were a lot of retrials back after Ring.
Wow.
Now, not guilt phase trials, just aggravation penalty phase trials like we've talked about before. Mm. Why not Djerf? Djerf didn't get one of those trials. His case came after a case called Summerlin v. Shryo, which went to the U.S. Supreme Court. Maybe I have that reversed. Shryo v. Summerlin. I can't remember. In any event, that case applied the retroactivity aspect of Ring to cases like Djerf's, which had already been final on appeal at the time that Ring was decided. Shryo says they had to draw a line somewhere, and they said cases that were a final on appeal pre-Ring don't merit resentencing. So why do I say all that? I say it because the judge in this case sentenced Djerf to death, and he did not get a resentencing from a jury. His sentence was allowed to stand. We good?
Yeah.
Okay.
Makes me think about Tyson.
Tyson was much earlier. This was in the 90s.
That's what I'm saying.
Was his analyzed? I'm certain that it was.
Yeah.
I'm certain that it was. Okay, so now where do we stand, right? So he's entered his plea. He does this several-day hearing trial to do sentencing. The judge ultimately finds that there's no real good mitigating factors and that the state had proven a number of aggravating factors.
Yes.
Right?
And so he puts out his appeal.
So, well, and because he was sentenced to death, his case has to be reviewed by the Arizona Supreme Court. We've also talked about that rule. Okay.
And then, they're basically all based on what we just talked about, colloquies, right? Mm-hmm. Talking about when there is a decision made, such as you're going to represent yourself, when you take a plea agreement, those type of Rule 11, all three of those things, specifically the judge has to be very careful to make sure that they confirm that the person knows what they're doing, knowingly, intelligently, voluntarily, do the things that they're saying they want to do. He pretty much goes back and attacks each of those things.
Yeah. So in his appeal, he says, well, my waiver of counsel wasn't voluntary. The Supreme Court disagrees and says, no, the judge actually did a pretty good job. Well, I'm actually Rule 11. I'm not competent. No, you actually are. The doctor put on the record and the court found appropriately that you are competent or were competent to proceed. And then he attacks the aggravators that the court found. And this one, the court does spend some time. In order to get to a death sentence, they had alleged especially cruel, heinous, and depraved murder, multiple murders, the idea that it was done for pecuniary gain or to get financial gain, and then the fact that one of the victims was under age 15. The cruel, heinous, and depraved aggravator, boy, if you go through each one of those murders?
He actually challenged that. That's the
But
thing.
you have to, don't
right,
you?
Right. But I mean,
let's be defense attorneys.
Right,
here for a
right,
minute.
exactly. You look at it and
challenge
just,
everything that you can challenge. But I get your point, which I think is
it gave the court the opportunity to walk through victim by victim. I mean, I guess it gave him the responsibility to do that.
Of course.
And walked him through victim by victim what they suffered and why it was cruel, depraved.
And I'm not going to rehash those facts. You heard them at the beginning. You know, were they cruel? Yes. Were they heinous? Yes. Were they depraved? Yes. I think it is interesting, you know, to touch on the pecuniary gain aspect of it. He tried to challenge that, but what was one of the first things that he did when he got into the home? He had Patricia take stuff and put it in their car, which he later stole. Right?
Because and we didn't cover that.
Revenge for Albert Jr. taking his own stuff.
Yeah, what's the argument there? I was just stealing my stuff back. Right. That's the OJ.
But the problem was he took more than his own stuff.
Right.
If you're going to get your own stuff back, leave everything else behind.
Well, OJ did the same thing. He got more than just his own stuff.
His memorabilia? You're talking about the sports stuff?
Yeah, you can't be doing that.
Don't do that.
Don't do that.
You know, and then the easy one, of course, is the multiple homicides. How are you going to challenge that? And then the other one was the child under age 15. How are you going to challenge that? I mean, he clearly was 5 years old. You know, his mitigating factors, this was, I thought, really interesting. He was 23 years old at the time and says, well, because of my young age, that should be a mitigating factor. And the court says, nope, you were smart enough to know different.
I found that fascinating, right? Because there are what we call statutory mitigators, right? Where it's just kind of laid out a list of these things can be mitigating. Don't you always use age?
Every time.
If they're 50, it's because they're 50 and they have no priors. If they're 20, they're only 20 years old. Frontal lobe isn't developed. I mean, age can be a mitigator.
Let me tell a short story. What is today, Thursday? Yesterday, I was in Mesa Municipal Court arguing. My client had, we went to trial on a bench trial. My client had been found guilty of a simple assault, a fight in the park. She was 20 at the time, and I had submitted a sentencing memorandum. Part of that memorandum said, Judge, she's only 20. Her frontal lobe is not fully developed. You know, that doesn't excuse her conduct, but it does help you to understand some of the lack of thought process that may have went into her decision making.
And that's a great point. It's about mitigation. Not innocence, right?
But this is a mitigating factor, and the court says you're 23. I don't think so.
I found that really fascinating. Right. How does the judge say 23 years old isn't old enough to? I mean, is too old for me to think that you were too young?
You're an adult over 21, and you committed 4 murders. I can understand the court's point. I guess it makes me worried a little bit because I use that mitigator a lot. Judge, he's only 20 years old.
I didn't even think you could just reject it. I thought you'd have to just say, well, I'm not going to give it a lot of weight, which is really what it was, I think. You know.
Yeah, and then the other one was his difficult family background. Now, there was no rebuttal that he had suffered or had a difficult childhood. What I thought was really interesting is the court says, well, there's no nexus between your difficult childhood and the murders. He says specifically, Arizona law states that a difficult family background is not relevant unless the defendant can establish that his family experiences is linked to his criminal behavior. He couldn't link the two, which, okay. That's hard.
Again, not anything I've ever done in this sentencing is link it. I mean, I guess I probably have.
Do. Judge, he grew up in, tough conditions, wherever, his dad is in prison, his mom is or whatever, drug addict. You got to give him the benefit of a break. And the court says, I don't see a link.
Yeah.
Shoot.
Interesting.
And then no remorse, as I talked about before. Instead, they say that his plea was more the result of overwhelming evidence than it was that he was remorseful for anything.
And one of his complaints, too, is to say, look, I didn't know when we showed up that day that I needed to be prepared to present witnesses and do this whole thing and that it was basically a trial.
He did complain about that.
And the thing is, the general rule is that if you're going to represent yourself, you have to be held to the same standards as if you were an attorney.
And that's part of that examination that the court does, as you said, that colloquy to determine knowing intelligently, voluntarily. You have to understand that you're held to that same standard.
So you can't say, I didn't know that would happen if a normal attorney would have known that that's what
Additionally,
you were doing.
He had advisory counsel.
He had advisory counsel. Now, I came up with, this is what I was writing down that distracted you.
Yeah, no, it's good.
What do you think of this argument if he would have made this argument? Because, he's saying, look, I didn't know, you shouldn't have let me waive counsel.
Right.
Right? That wasn't knowing and voluntary, and that led to a whole basically cascade of problems with the case, right?
Okay.
Don't you think a supporting argument for that would have been like, if I'd had an attorney, they never even would have pitched me that plea offer, and I would have known not to take that. The fact that I took a plea offer That fact alone, how often have you seen this, Judge? Somebody take a plea offer that leaves death on the table? Doesn't that just show that the prosecutor took advantage of my lack of knowledge or my lack of having counsel, or that I shouldn't have been acting as my own counsel because I just fell for a really stupid plea?
And I think I 100% agree with you. And I also think, what was our comment at the beginning of our discussion today? Gosh, this one's strange. He entered into a plea in a death case. As experienced criminal defense lawyers, you and me, we don't see this. And you have now this unique circumstance where he enters into a plea. Why? Probably because he waived counsel. I mean, it's sort of this, self-fulfilling prophecy situation, right? Where it's like, I'm going to waive counsel and then I'm going to enter into a plea that nobody else on earth would do had they had counsel.
Yeah. Yeah.
I buy it. Now, is it a reason for reversal? I don't know. I think what the court says here, probably what the court, I don't want to second guess. Well, I don't want to second guess the court here, but I think when you take into account the overwhelming evidence and sort of the horrible nature of the murders, the court's going to say, it's probably fine.
What do we call that? Outcome-driven.
Outcome-based jurisprudence. Yeah. So a couple of historical things that are interesting. We mentioned that he was executed just a couple of weeks ago. That was on October 17th. He actually, leading up to his execution, he released a letter to the media. And this letter, it's a complete confession letter.
Wow.
That I want to read portions of it. He says, on September 14th, 1993, I forced my way into the home of the Luna family and brutally murdered 4 innocent people in a cruel, heinous, and depraved manner. Over the past 32 years, attorneys assigned to my case have worked to save my life and find a reason why I committed these murders. He goes on to say the results, they can never excuse the harm I caused, harm that has continued for decades and will likely continue for many more years to come. Harm that goes beyond the Luna family and all who knew and loved them, from the first police officers who entered to the fire and others who witnessed the carnage when they investigated it. Worst of all, the harm I caused to Albert Luna Jr., the boy, who unknowingly walked into his own home and discovering what I had left behind and the guilt he had to feel learning why it happened. Anyway, he goes on. He says, I've had a lot of time to review my life over the past 32 years, from stealing from my dad and others as a young child to physical abuse of 2 fellow high school students and a lot of criminal mischief in between. I have done far more harm than good. I mean, really, he sort of comes to himself here. I am truly sorry for all the pain that I caused everyone affected by the murders I committed. I appreciate the work my legal team has done to prepare for clemency. I must decline. If I can't find a reason to spare my life, what reason would anyone else have? I hope death brings some measure of peace.
Wow.
Yeah. Interesting.
Yeah.
I also watched a news conference after the execution had taken place. As you know, there are always media representatives who witness the death sentence, the county attorney, others who, the AG, others who are involved in those things. Media representatives said that his death, they kind of went through the timeline. It was essentially uneventful. They inserted the IVs and
Lethal
such.
Injection,
and he appeared to sort of breathe heavily. He then went to sleep, and then it was over. There was no more signs of life. So interesting. I mean, sad all the way around. I've said this before. Sad life, this guy. Obviously a cruel person. But horrible, horrible things happened to the Luna family. And it ends with him, being executed. So it closes that chapter.
Yeah, and that's interesting to hear. I know that there were really a halt on those executions in Arizona because there were some issues with the delay in people dying and the suffering that they were going through in that process. So that's interesting to hear, and it's always a tragedy all around. There's no
If there's one thing that I've learned from 2 decades now of practicing criminal law, rarely are there winners on any side of any of this. It harms victims. It harms our clients, the defendants. It's difficult. The best we can do is try to mitigate some of the damage. done. In our roles, prosecutors try to do the same things with the victims. We wrestle with them, we fight with them, we wrestle with judges. But this is the system that we've got.
Yeah, and especially in a homicide, and I think that's what's maybe the juxtaposition. People say, well, that must be a miserable career, is that a lot of the case types that we handle, especially when you compare them to a homicide, really do have a lot of hope. A lot of, I think, winners, people who do come out from that where they get to learn a lesson from it and improve their life in the future. Victims, who can move forward, in a positive way. And so that is encouraging, I guess, from our perspective. We do see a lot of really inspiring success stories as far as that goes. But when it comes to homicide, it's just a losing proposition.
Yeah, and I've represented, as you have, homicide defendants, clients accused of homicide. I've represented clients accused of all sorts of things. My number one goal as their lawyer is to passionately and zealously defend them, as far as the law will allow me to do it. And in some cases, we get charges dropped and cases dismissed. Other cases, that doesn't happen, but we still minimize those consequences and try to help our client piece their life back together and move forward. And it's a battle. Prosecutors, of course, would, talk dirty about us and say, oh, you guys are out there helping. We're here to help people as they are, So that's what we do.
And most of them get it. Most prosecutors get it.
Suffice it to say that, I'll do my job, you'll do yours, they'll do theirs. And
I'll feel absolutely fantastic about it because I'm defending the Constitution every time I defend somebody and make sure that they don't get convicted wrongly.
Yeah. And we defend people, individuals,
That's what I love about it.
That's right.
Yeah.
All right, that's a wrap.
Thanks, brother.
Okay.